SJC-12786, Commonwealth v. Lewis, T. Claudio.
Mr. Power, good morning.
Morning, Mr. Chief Justice, and may it please the court, Andrew Power for Mr. Luis Claudio. Now, in this case, I'd like to begin with the findings of the motion judge, specifically that a motion to withdraw a guilty plea in this case would satisfy the Ferrara-Scott test. The motion judge specifically made 4 points that I'd like to present to the court. First, that government misconduct preceded the guilty plea and occurred in this case because the tainted conviction was a predicate for subsequent sentencing enhancements under the habitual offender statute. Second, but for those enhancements, Mr. Claudio would have insisted on going to trial. Third, Mr. Claudio's belief in the weakness of the Commonwealth's case was borne out by the Commonwealth's difficulty in summoning the accuser to testify at trial. And fourth, that it was rational for Mr. Claudio to feel coerced to plead guilty in this situation by the threat of a mandatory life sentence were he to proceed to trial and be convicted. So the judge has found that my client presented a meritorious claim under Rule 30B. The only obstacle now to presenting that claim with an actual motion for new trial is the threat of harsher punishment. And that's why my client has come to the court, and that's why you have this reported question before you, to extend Bridgman 1 type protections that would reduce the risk of harsher punishment.
Mr. Pott, the complicated part of this fact pattern is the minimum mandatory 10 for the age discrepancy.
Yes.
Right. So I mean, typically the enhancements would only be for the tainted drug case, but here we have another minimum mandatory that your client was not exposed to via the plea. I guess your argument would be that that's what the motion judge took into account when he made the second finding of Ferrara-Scott, the but-for, right?
He did, and that's also part of the finding that these enhancements would come back. The mandatory 10, the habitual offender would not come back, but were he to plead and succeed, then, I mean, withdraw the plea and succeed, then the 10-year sentences could actually run
two of them
concurrently,
right,
or consecutively. So he'd be facing a 20-year sentence where now he received a 6 to 8 year sentence. He's in the middle of that, and so he'd be in a much worse position were he to succeed in his plea withdrawal motion.
So if he had kept his mouth shut, he'd be in a better position, basically, for the Farrak error.
Exactly, which was what the court said was the problem in Bridgman 1. It's the defendant is bearing the burden of making the choice. Do I pursue a meritorious motion to withdraw my guilty plea and face significantly harsher punishment if I succeed? Or do I simply acknowledge the fact that, yes, there was a tainted predicate conviction in my case, which induced me to plead guilty, but I don't want to do anything about it because I don't want to face that harsher punishment. And this court said in Bridgman 1 that that burden should be on the Commonwealth, not on the defendant. So Mr. Claudio is asking for these Bridgman 1 type protections, and the first issue I think that has been raised is that Bridgman 1 technically does not mention Farrak defendants or Farrak misconduct. Bridgman 1 on its face applies to Dukin defendants only. But I think there's general agreement, and I think the Commonwealth has conceded at various points, that a Bridgman 1 protection could apply to Farrak defendants in certain circumstances. They said that in Judge Carey's Cotto order of 2017. They also made that concession to the motion judge in this case. And I think the reason that Farrak defendants are not mentioned in the Bridgman opinion is because this court was not aware of the extent of Farrak's misconduct at that time.
How far are you willing to go on this? I'm trying to understand it. I get, in your case, this habitual offender is directly predicated on the Farrak conviction. Say we've just got some person who, he's a drug offender, he's got a couple of Farrak offenses, he pleads guilty to another offense, and it's just background information that he has this many convictions. Is whenever someone has in their history a Farrak conviction, are they going to be able, and they plead guilty, are they going to be able to say, hey, that influenced my decision, that I've got, I had 2 priors or something like that?
Where it's not a predicate.
Yeah.
Yeah.
It's just on his BOP.
Yeah, I would say no, Your Honor. That would be the Wallace situation, basically, where he wouldn't be able to establish the nexus between the prior conviction and the instant case. So the unique thing about these, ACCA enhancements or habitual offender enhancements is it actually has to be voted on by the grand jury. It's presented in the indictment, so it's actually part of the case. So,
But is that the next case you bring where, a lot of us were Superior Court judges and you're sentenced based upon a staircase and someone has a bad history, and the bad history could be, as Justice Kafka says, 3 tainted Farrak or Dukin cases, right? And then you give the person a certain sentence. Are you back in court saying do Ferreira-Scott analysis when it's not a predicate?
well, I think the question here is actually Bridgman 1 protections. The defendant has a right to go to court and say that and to file a motion. The question is, are they going to do it and risk harsher punishment and perhaps be discouraged from doing it, or are they going to have this sort of preliminary, I call it a pathway to justice. It's basically just opening the court doors. They can come to court, they can present their claim without fear of harsher punishment, and it doesn't necessarily guarantee relief. They still have to satisfy the Ferrara-Scott
So are you saying then,
test.
whenever you have a BOP that includes a Farrak conviction, that we got a lot to do in the judicial system? Are we going to be saying that, okay, anyone can bring a claim, why not bring it then? I mean, you got no downside, why not bring it? I'm just trying to, or should we write a decision that says we limit this to habitual offenders or where there's this direct causal connection?
Well, arguing on behalf of Mr. Claudio only, I think we would have no problem if he said yes to this reported question based on a habitual offender predicate or an ACCA predicate. But also there's a very good, and we support the amicus brief in this, that it could be broader, and it really could be left to the discretion of the motion judge, as the motion judge did in this case. So what we did here is we basically presented the motion incorporating all of the information, the affidavits, the drug certificates, everything was presented to the judge.
Doesn't that raise a problem that we're going to have, if you have a Farrak case and a long history of criminal offenses after that, every single one of your guilty pleas is potentially going to be reopened by that?
You still have to demonstrate the nexus. So you have the Farrak case, so you satisfy the preceding part of it, but you're nowhere near satisfying the nexus element.
You're always going to get the first requirement because there's egregious government misconduct by its nature.
Yes, so by its nature,
So what you're saying is
potentially there are other
So if you're
older
saying
pleas.
if a Farrak conviction or Dukin conviction were just one of many convictions on a BOP, that's not going to get you the nexus.
That's not going to get you the nexus. You really have to demonstrate that it's actually part of the case.
What about this situation? Let's say that it's, Commonwealth has a strong case, it's a habitual offender case, there's 5 or 6 possible convictions that would satisfy predicates, and the Commonwealth puts 3 of them into the grand jury. And one of the 3 is a Farrak case, and it's a plea out to a predicate with 1 prior conviction. So there's a lot going on there. The defendant has a reasonable argument to say, well, I didn't plead because I was looking at life. On the other hand, the Commonwealth has, well, there were these 2 others, we cut it down two drops, and we had these other choices that we could have presented in front of the grand jury instead of Farrak. So there's going to be all sorts of permeations here. Just that permeation, what's the result there?
On that permeation, I think you draw the line at what appears on the face of the indictment is, on a habitual offender, there would normally be two predicate offenses listed. Is either one of those tainted by Farrak's misconduct? If yes, you can go forward. If no, you're going to have trouble establishing the nexus element of it.
Well, the nexus element is a prejudice element. I mean, you've got to show prejudice. Nothing we do here will affect the need for the judge below to make a finding of prejudice arising from the Farrak conviction, correct?
Absolutely, and that's why I say this protection is just a first step. There still has to be a finding by the judge on the second prong that but for this threat, would the defendant have insisted on going to trial?
And in the example Justice Lowy gave, a judge reasonably could say there's no prejudice because they could have re-indicted you on one of the other uncharged predicates.
That's true, if they could show that, if they could bring those, and yes.
So if you prevail, it means that if there is a finding of prejudice, then the Commonwealth cannot charge a more serious crime or seek a higher sentence.
Correct, pursuant to the Bridgman principle.
And if you don't prevail, a Farrak defendant could still bring a motion for new trial. Just means that that particular defendant, if he or she prevails, will be facing the prospect of a longer sentence.
Exactly, which was the risk that this court acknowledged in Bridgman that would be unfair to impose on these defendants. So,
I'm not sure I follow that, though. If we do what you want us to do, which is to say it's capped, the prejudice inquiry would take place in that proceeding, right? I'm not sure whether the cart follows the horse. And maybe I misunderstand what the point the Chief just made, but if you win, I take it you want us to say in an order, wherever anyone pled guilty to a Farrak conviction, and there's a habitual offender case, that when any new trial motion, regardless, is going to be protected? Or do we have to find in the individual case prejudice first?
well, the protection would be the granting of protection would be determined by the motion judge.
So the defendant would face the risk that when he made that new trial motion, that the judge could say, hey, it didn't impact on you, then we can't increase the sentence?
Well, this would give the defendant fair notice, basically, that if you proceed with your new trial motion, your motion to withdraw a guilty plea, you run the risk of a higher charge, of re-prosecution and more severe sentencing.
Even if you win?
Even if you win.
Even if you win today?
That's if you get by.
If you don't get the Bridgman 1 protections, then you can still proceed. So the important thing is it's almost a two-step process.
But you have to pass through
Yes, you
Frere
have to-
Scott.
you
So,
have
so
to,
in
exactly.
the hypothetical could be that someone gets a 7-year minimum, someone's charged with a 7-year minimum mandatory for a buy bust to an undercover police officer. They have them dead to rights. There's a predicate, which is a Farrak predicate. Bring a motion in the Commonwealth. They negotiated out. Commonwealth gives them possession with intent, gives them a year of probation. Great deal. They bring a motion for new trial. A trial judge could say, "Yep, you satisfied Frere Scott because of egregious government misconduct in the." But come on, you got the deal of a lifetime. There's no prejudice, and you could deny the motion on those facts.
Yes, and I think it's important to leave it to the discretion of the motion judge, because as this court has recognized, these are very fact-specific inquiries, and it's very hard to sort of come up with a one-size-fits-all solution.
Right, but my concern was that if you define this broadly enough, everyone who has a Farrak conviction on their BOP, no matter what, can bring such a motion. right? It would open up the ability to file such a motion in every single case where anyone has one of these on their BOP. I understand it won't automatically result, but that proceeding will be kicked in every single case, right?
Proceeding, if they decide to withdraw their guilt, this really has no impact on the merits of the motion to withdraw a plea. But if they decide to do it, then they could ask for Bridgman 1 protections, and depending on the judge's findings, that could be either denied or allowed, and then they could decide whether this is worth proceeding in a, Rule 30B context.
Right.
But this only affects stage 2. Basically, unless there's a finding of prejudice, that is, unless the judge says you would not have pleaded guilty if you did not have this Farrar conviction, we don't get to the issue that you have. It's only where the judge says, yeah, he would actually not have pleaded guilty if there were not the Farrar conviction that you even reach this issue.
Yes.
And what you're asking us to do is basically unwind the harm that was caused by Farrar,
Exactly. And that's,
or collateral consequences.
Yes, and that was a key part of the Bridgman ruling as well.
Yeah, I get it when it's an habitual offender or armed criminal context. I don't get it when it's in the BOP context, when the possibility of it is so light, where there's no causal connection, except for the possibility of the staircase sentencing that Justice Gaziano described.
Mm-hmm.
And you could end up creating a giant burden on the court system for these sort of second looks when there's no connection.
I think the defendants will always have the right to move to withdraw their guilty pleas in that situation. So whether they are going to be encouraged to do so by this ruling, I think their attorneys may have advice for them on the merits of their case before they burden the court with any further litigation.
Counsel, Justice Gaziano suggested that this defendant receive the deal of the century on this sentence. What
No,
is?
that was a hypothetical.
Oh, I'm sorry.
That wasn't this
never mind,
defendant. That was
Next to 8 years to 10 years probation is not the deal of the
even I
century.
wouldn't call that the deal of the century.
I never understand them, so.
Thank you. If you have no further questions, I'll rest.
Mr. Wendell.
Good morning. May it please the court, Assistant District Attorney John Wendell for the Commonwealth. I'd like to begin by addressing a point my brother made. He said the Commonwealth conceded the applicability of the Bridgman rule. We conceded the applicability of the Bridgman rule in rather specific circumstances. We conceded it in the context of handling what are we going to do with the Amherst Lab drug cases in the litigation in Cotto before Judge Carey. In the motion at issue here that led to the reported question, I conceded that it would be applicable if not for the fact that it was rendered moot by the court's decision in CPCS versus AG. So the Commonwealth has never conceded the applicability of the Bridgman rule.
But why would they get less protection with more egregious harm?
They don't, Your Honor. Your Honor actually made that point quite clear, that that was the purpose of the greater remedy in CPCS.
So so what we said is we didn't go through the Bridgman protocol because of Farrar.
Right.
Because of the misconduct. So rather than going through that, we just eliminated all the convictions, all right?
Yes.
So now we're dealing with the consequences of that order. How do we unwind that to make people whole? And your argument could be that they get less protection. They don't get the benefit of a Bridgman cap because they're not a Dukin, there's no Dukin harm. But you'd actually have more harm because they're a Farrar defendant.
Your Honor, the only answer I can give to that is that there's no harm left to unwind, because Bridgman is strictly limited to the Dukin drug cases. CPCS is strictly limited to the Amherst Lab drug cases. There's no such thing as a Bridgman defendant charged with rape. There's no such thing as a Farrar defendant charged with rape. The defendant is not a Farrar defendant insofar as he was charged with aggravated rape. He's a Faraq defendant only insofar as he has one of
But
these
the
qualifying
government
predicates.
used the Faraq conviction to enhance his sentence, right?
We did, Your Honor, but this goes to the question of whether or not this is actually moot here. We used this predicate, but that doesn't mean that this defendant satisfies either prong of the Ferrara-Scott test. He might be eligible for some manner of post-conviction relief.
Is that an abuse of discretion, though? Because the motion judge found both prongs of Ferrara-Scott satisfied, right?
Yes, the motion judge abused his discretion.
Who was the plea judge, too,
Yes.
right?
He abused his discretion in making those rulings in this case because there was no briefing, much less argument, on that question presented to him. The sole question was whether this defendant was entitled to the Bridgman 1 sentence protection. Had there been a discussion of whether he was entitled to entitled to relief under Ferrara-Scott, the Commonwealth would have opposed such a motion, and there would have been substantial further litigation beyond what has actually taken place in this case.
But the motion hasn't been formally brought.
Correct, Your Honor.
So the judge's rulings only say this is not, I read the judge's rulings to essentially be a message to SJC, this is not hypothetical. I'm going to seriously consider the possibility and likely make a finding of prejudice here, so if the motion is brought. But he's not going to bring the motion if he's facing the prospect of getting a longer sentence upon retrial, so he was only essentially indicating where he is likely to be. He hasn't made a ruling yet, correct?
Fair enough, but the point remains that he's still incorrect that there's any potential of the defendant obtaining relief under Ferrara-Scott in this case. The defendant may be entitled to relief based upon newly discovered evidence, something to that effect, but he cannot satisfy the first prong of the Ferrara-Scott test.
I don't get that. You've got a conduct which is as or more egregious in Faraq as you have in Dukin. Agreed?
Yes, Your Honor.
And if the judge were to find, you can argue that, Your Honor, he would still, even without the Faraq conviction, he still would have pled guilty because he was facing the 10-year mandatory. You can argue that to Judge Mason, but if Judge Mason were to say, no, I'm convinced that this guy pled guilty only because he was not prepared to throw the dice, where a mandatory life sentence was the consequence of losing on the dice throw, why would he not be prejudiced if that's the finding?
If I may, I disagree with Your Honor that the question of nexus is a question of prejudice. The question of nexus is a separate question from the question of prejudice. Nexus goes to prong one. Was the government misconduct in this case? Prejudice goes to prong two. Would this individual not have pleaded guilty?
But you were basically intending to increase the sentence from 10 years to life because of the Faraq conviction.
That's still, the Commonwealth's position is that still does not satisfy the very specific, very limited parameters of the nexus requirement of Scott. In Scott, interestingly enough, the court did discuss this in the context of the second prong, whether the misconduct detracts from the evidence that forms the factual basis for the defendant's plea to the underlying offense. The defendant pleaded to rape, simple rape. A drug certificate has nothing to do with a charge of simple rape. Whether the evidence could be used to impeach any essential witness for the Commonwealth's case, Faraq wasn't even a potential witness. She was in jail. So there's no possible way she could be an essential witness.
But he pleads to the rape to get rid of the habitual offender. That's why he pleaded, and that may be why he pled.
Yes, Your Honor. But
Nexus is present. It's not, I understand your point of we were talking about the BOP situation, but here because I do believe the nexus and the prejudice are different inquiries, but I don't see the nexus here not being there because of the predicate offense charge, and he gets rid of it in the plea.
I guess the best answer I can give to that goes back to what Williams is actually about, and I think I wasn't.
I'll let Justice Cipher explain that.
Look, I was on the appeals court then, I was just doing what I thought the SJC wanted.
Well, in any case, with Williams, and Your Honor, I must say that despite the potential consequences the Commonwealth may have with the application of Williams, the fundamental part of Williams is that Williams is not actually about Ferrara Scott as such. That it was a Ferrara Scott case, given the very particular circumstances of that case, but it was not a Ferrara Scott case as such. It was a case in which the individual had a misunderstanding about the potential maximum consequences of his plea due to a predicate conviction that thereafter went away. But predicate convictions can go away for any number of reasons. They could go away due to ineffective assistance of counsel, newly discovered evidence. There are probably other ways in which people might obtain success on a motion to withdraw their plea that I'm not thinking of. And in any of those cases, the individual would still find themselves in the situation of, I pleaded to avoid the sentence enhancement, I no longer have the predicate, therefore I want to withdraw my plea because I didn't really get a deal. That's what Williams is about. Williams is not a Ferrara Scott case. Williams is not a withdrawal solely due to the government misconduct. It's a withdrawal due to what ends up being a peculiar consequence of that misconduct, not the misconduct directly. And the Bridgman rule, the court stated that the Bridgman sentencing protection applies where someone wishes to withdraw their plea solely due to Dukin's misconduct. So anyone who obtains relief under Williams is not obtaining relief solely due to Dukin's misconduct, solely due to Farrak's misconduct. So there's a possibility that this defendant will be able to obtain relief. That is going to be a very fact-specific question, depending on numerous factors, but it's not going to be solely due to Farrak's misconduct. So even if this court were to answer the question yes, the defendant would still not be entitled to this protection. And if I may, I'd like to address the question of how are we supposed to implement this if the court answers it yes. Every single case, there would have to be an examination of the merits of the Ferrara-Scott motion, of any, whether this could be potentially a Ferrara-Scott motion, before we ever got to the question of whether the individual is entitled to a Bridgman protection. And actually, part of the
I don't understand that.
well, if it's not a withdrawal due to Farrak's misconduct, solely due to Farrak's misconduct, then it is not a withdrawal that meets the requirements of the Bridgman rule as expanded. And so therefore we have to reach that question before we reach...
Okay, but one difference in Bridgman is that Bridgman at that time did not require the dismissal of the Dukin, of all the Dukin cases.
That's correct.
In Farrak, it did. So the only issues you're likely to find is the person is not going to have the Farrak conviction on his or anymore, but he or she is only going to be in this type of situation saying, I would never have pled guilty if not for the consequences of the Farrak conviction. So...
Right, but that goes...
Why is that so hard?
It goes back to Justice Kafker's point of, well, what actually happened here? Are they wishing to withdraw their plea solely because, oh, they had a Farrak? It goes back to the question that is addressed by Williams. And I do want to make very clear, if the defendant is entitled to relief under Williams, then there's no possibility of him truly going back to the way things were prior to his plea. Because if we had another predicate conviction that we could use in place of this tainted one that has since been disposed of, we would still be able to charge this defendant as a habitual offender, and the sole reason...
That's just Slowey's hypothetical in the prior argument, where if that were the case and the judge went through the Ferrara-Scott analysis, you'd win on prong two.
We would, yes. And
So
that-
how are you harmed?
Well, that's the point, Your Honor, is that there's no way for an individual to, the point goes to what Bridgman was about. Bridgman is about, the direct quote is that it is unfair to,
But big picture, right? What Bridgman and Farrak are about are undoing the harm caused by these two chemists.
yes,
And what we're trying to do in all these cases is to put people back in that position and undo this ungodly harm in all its permutations.
yes, Your Honor,
Right? So that's kind of the big picture we're trying here.
of course. And the harm potential to this defendant as a result of Farrak's misconduct was the fact that he was charged as a habitual offender. That is the harm that he faced.
So with that sort of Damocles over his head, he pled guilty and got the 6 to 8.
Yes. To unwind that harm, we take it back to he cannot be charged as a habitual offender based upon this predicate.
Okay,
He-
so now he brings the motion to vindicate his Farrak rights,
Yes.
and then he now goes to jail for 20 years.
Yes.
Why would he bring the motion?
He might not.
Sane.
He might not, Your Honor. But the reason that he goes to jail for 20 years has nothing to do.
I know, I get the fact that he probably shouldn't have allegedly raped someone afterwards. I get that point, but we're still trying to undo the harm.
Yes. Even there, the fact that he faces the 20 years, it's not about what Farrak did. It has nothing to do with what Farrak did. It's about the fact that he's charged with aggravated rape, and we let him plead to something lesser, a lesser included offense. If the goal is to unwind the harm, then a yes answer to this question overextends that, because the harm done has to do with the sentence enhancement of being a habitual offender. He will obtain that relief. He will not be chargeable as a habitual offender. And all things considered, most likely he will probably not actually face a life sentence. But the fact that he will then stand charged again as an aggravated rapist, as opposed to charged with simple rape, sentence capped at 6 to 8 years, the fact that he returns to that position has nothing whatever to do with Farrak's misconduct. It has to do simply with the nature of the incident itself, the underlying facts.
But why was your office willing to reduce the charges and give him a 68 in the first place?
That actually goes to an interesting point that's brought up in Bridgman. Bridgman talks about that these plea deals are made viewed as mutually beneficial. That doesn't really apply, I would submit, in victim cases, because where we have a victim, there is another calculus beyond simply how much time it's going to take to try this case and what the strength of the case is versus the potential defenses. With a victim case, there's also the fact that we have to put the victim on the stand, subject the victim to the secondary trauma of having to testify. And so I would submit that in victim cases, especially sexual assault cases, the Commonwealth very frequently makes bad deals to spare the victim the pain of having to take the stand and testify, and also to simply resolve this matter quickly and efficiently and with certainty. Whereas with a drug case, our primary concern is saving time and saving money. So it's a fundamentally different calculus that we don't make necessarily mutually beneficial deals. And I would submit that we didn't do so here. So ultimately, that portion of the Bridgman analysis does not apply to a victim case. And that, more than anything, is why the harm of Farrak's misconduct being unwound stops with the Williams relief. You get a new trial, you're no longer charged subject to the sentence enhancement.
Okay.
So,
Thank you.
thank you.
We'll take our morning break.